Court is reconvened.
Please be seated. The second case this morning is Darren Lee Arends versus the State of Washington. Opening for 15 minutes, we have Mr. Kertchen, and in response for 20 minutes, Mr. Sugg, and 5 minutes reserved for rebuttal. So, counsel, you may proceed.
Chief Justice Stevens, may it please the court. My name is Vitaliy Kertchen. I'm here for the petitioner in this matter, Darren Arends. The Court of Appeals in this case erred because it disregarded the correct vested rights framework in favor of a legislative intent approach, thereby vitiating the complete concept of vested rights entirely. A vested rights analysis asks, does the statute operate prospectively or retrospectively? It asks, what is the precipitating event? And does the statute impart a present fixed right of future enjoyment? To determine the precipitating event, we look to the subject matter of the statute.
Is it the right to have rights restored that vested? Is it the right to petition in a certain venue that vested? What exactly vested?
The entire subsection for former 9410404 vested. The venue provision of 4 is subparagraph or paragraph B, whereas the substantive portion is paragraph A. And so everything under 4 is our position vested, including the venue provision.
Counsel, can we tell from this record whether in fact there was vesting, whether your client met all the requirements of the former statute?
My answer to that, Your Honor, would be that there was no objection from the state regarding the merits of the former statute.
I thought one of the boxes checked that in fact not all the requirements were met on that form that the county prosecutor filed.
Correct, Your Honor. That was, so that order was under the new statute, but we're asking to proceed under the old statute.
So we just don't have enough of a record right now to even determine whether your client had vested under the old statute, because it was never considered.
I suppose, knowing what I know, I suppose I know he has, but I understand where you're coming from, Your Honor. And
in the record.
Correct, yes, you're right. I think we probably do, but it doesn't have to be decided because the case can be remanded to the Superior Court with a finding of that the vested right does exist under the former statute, and then the Superior Court could make that factual finding if it needs to, that the previous conditions had been met.
Can I ask a follow-up to that? Because I had a similar question, because under either version, besides meeting requirements at the time of the petition, at the time of the granting, one has to still remain crime-free. I mean, there's that additional requirement. But it seems like under your argument, you're saying that would go to whether one meets the conditions of the statute to obtain the relief, but that the vesting would happen at the moment of, I guess, at that initial moment. Because what concerned me is that the timing in the statute is not just like at the moment of petition. It's the requirement seems to carry all the way forward to the date of the hearing or of the action.
Sure. So our position is that the right vested as of the date, if the individual had been fully eligible on the date the law changed, which is July 23rd, 2020.
But that's what I'm getting at, is how can one be fully eligible on that date when one of the eligibility requirements is that you remain without any further, violations all the way up until the granting?
Well, that's not necessarily correct, Your Honor, because in Dennis, the court ruled that under the old statute it can be any 5 years. I think perhaps maybe Your Honor is referencing the not currently charged prong over the former statute.
I think that is. I didn't look at the exact language, but yes, I think you're right.
Okay, sure. So yes, I agree that would need to be tested both as of the date that the statute changed and the date that the petition was granted. That is true. So in that particular instance, if the petitioner had no pending charges as of July 23rd, 2023, and had met all the other conditions of the former statute, that right would have vested. And so long as there are no pending charges at the time that the petition is granted, that person would have been eligible for an order at that time.
You're not arguing that Dennis controls, you're arguing that TK controls, aren't you?
Yes, Your Honor, definitely. A TK is our primary case that we are relying on, and we do believe as close to dispositive as it can get without being directly and precisely on
Let
point.
me ask you a question then about TK, because TK dealt with a juvenile, or former juvenile, I guess we're all former juveniles,
Sure.
petitioning for sealing something. That person will never be a juvenile again, as none of us will ever be. That's different than this case, isn't it? Here, we don't have that issue. We have the issue of someone who's got to show that they continue to be eligible at the time they petition, at the time that the court orders restoration. Isn't that a different fact pattern and distinguishable from TK?
No, I don't believe so, Your Honor. I believe in the statute, the sealing statute at the time and currently, one of the requirements, just like the firearm restoration statute, was that there would be no pending charges. And so if that was not a consideration in TK, there's no reason why that needs to be a consideration in this case either. Even though that person is no longer a juvenile at the time, and actually I don't remember, to be frank, whether the person petitioning to seal at the time was a juvenile or not, but it doesn't really matter. But still one of the requirements was no pending cases and 2 years of no crimes. Here we have no pending cases and 5 years of no crimes. And I don't see a distinction between those two things, at least not in the way the statute operates. Of course, the statutes grant different relief.
Well, in TK, potentially the person would not be eligible any longer because there was a 10-year period instead of the 2-year period. So it actually took away their ability to seal. But here, there's still the ability. It's just a question of who has the responsibility of contacting the victim and doing the footwork required. Isn't that true?
In TK, the issue was whether a Class A sex offense could be sealed or not whether the time period was extended. And so in TK, the legislative amendments removed that ability completely.
But here, that's not the case. The ability to restore rights isn't removed. It's just a requirement that you file it somewhere else, right?
They are removed as to my client because he can't file in any county because the venue provision was changed.
Well, counsel, going to venue, every court in the state of Washington presumably has jurisdiction over these cases. So jurisdiction being different, that is to say, venue, when you file in the wrong venue, there has to be a motion by the other party to change venue to the proper venue. Mm-hmm. So wouldn't the burden here be on the state to say that the venue chosen by your client was an improper venue and then move the court to change venue?
Well, the state exactly did that. Well, they did the first portion of that, Your Honor. I think perhaps you are referencing State v. Manuel, which is the Court of Appeals Division 1 decision, which states that the restoration, the venue provisions of the former statute are not jurisdictional. They're venue provisions, and that every superior court has jurisdiction. And venue can be waived. However, the state, as far as represented by the Snohomish County Prosecutor's Office, chose not to waive venue, and in fact chose to contest venue by filing a response that says, my client doesn't have venue, and there is no other venue, and I do agree there's no other venue. I don't know where to move this court.
Okay, so if there is no venue, no other venue, and the person has a right to bring a petition for restoration of rights, and there is no venue in the state of Washington that could provide the opportunity to be heard on a right that he has. I mean, whether it's vested or not, there's a right to petition if you have met certain criteria. Why would the superior court not then retain venue, saying, well, there is no other venue, I can't move venue, there is no other venue?
Your Honor, all I can say is that the commissioner denied our petition summarily without even a hearing. Honestly, we didn't even get to argue the case. And so the state filed an objection, and the next day the commissioner signed a denial order, and we went to the appeals court from there. So that wasn't even a consideration that the superior court had.
But wouldn't it legitimately be a consideration that your client would have? That is, if the state wants to move venue, well, okay, fine, move venue. Oh, there is no venue. Well, then you've just been deprived of statutory right that without cause, I mean, as far as I can see.
I understand where you're coming from, Your Honor. I would say that were we to have made that argument, we'd probably end up back here anyway, so.
I
what-
understand that, but isn't there a big difference between a venue case and a vested rights case? In terms of the law that you're arguing and the precedent that you're setting?
In terms of trial strategy or in terms of litigation strategy, we feel like TK is enough on point that obviously we believe we should prevail under TK.
Of course you do, but what if you don't?
Well, then we'll see you again next year. Or in 2 years, however long it takes.
Counsel, what version of the statute are you saying that your client vested under?
The former version of the
What
statute.
year?
What's that?
What year? What year was that amended?
2023 is the operative amendment that.
But that's not the one you're trying to seek relief under. What's the year of the statute that you're trying to seek relief under?
Okay, so prior to 2023, when that subsection was repealed, the last time it was amended in any substance was, I believe, 2011, which is when the venue provisions were added. Is that what you're asking?
Correct. So had your client already met all the requirements required under the 2011 statute?
Our position is yes.
Okay, even though that's not in the record, as we talked about before.
It may not be precisely in the record, and there was no factual finding to that effect by the Superior Court, but that can certainly be done if we get to a fact-finding hearing on this case.
Can I move you back to Justice Madsen's question, at least as I understood it? I think the question was, if we decide this under the current version of the statute, which seems to preclude Mr. Arends from having any venue in the state of Washington, despite the fact that there's a claim he can raise in the state of Washington that every Superior Court would have jurisdiction over, don't we have to construe the statute to say venue stays where it was filed because there is no alternative venue? In other words, I hear her question as a different way to get to the result that you're seeking. Your argument was the old statute has to apply and rights vested. I heard Justice Madsen asking about, well, even if the new statute applies, don't you have to have a venue?
That would be a question for a different day, Your Honor. That the issue isn't briefed, and none of the parties anticipated that particular question. I think that would be, I think that this case in particular needs to be decided on the vested rights question, and if there's a different alternative argument that exists, that can be developed as needed.
Counsel, I'd like to ask about your reliance on TK as controlling in this case. TK dealt with the juvenile sealing the record, privacy issues. In this case, it seems like the purpose behind it is public safety. And it appears, if we follow your resolution, that may undermine that purpose. Could you flush that out for me, why you believe TK is controlling here?
Yes, Your Honor, of course, Your Honor. Thank you. The purpose of the statute in terms of legislative intent or public safety is in a posit for a couple of reasons. One is legislative intent is not a question that determines the existence of a vested right in any of the case law. The question of legislative intent is limited to asking, does the legislature intend for this statute to apply prospectively or retroactively? That's it. Every other decision, including TK, in Ray Carrier, and every other vested rights decision does not hinge that question on the vested right. Also, if we look at TK, the state in that case made the argument, and it said, in fact, I'd like to read it because I think it's important, because rehabilitation is a theme of the state's argument, and it was of the Court of Appeals decision, that the word rehabilitation only appears once in the entire TK decision. That states, here the state asserts the statute and its amendments are remedial because they're designed to protect the public by maintaining records of serious offenders and by extending the time spent in the community by juveniles convicted of lesser offenses to demonstrate rehabilitation. The state also contends the amendments are procedural, merely regulating record keeping. And a paragraph later, the court discounts that argument, saying even if the 97 amendments at issue here are remedial, the statute will not be applied retroactively if it affects a substantive or vested right. And so the question of public safety was something floated by the state in its argument in TK that this court rejected. And it's just not a, we look at the way that the subject matter of the statute, which is what does the statute do and how does it operate? What does it control or regulate? In TK, it was the conditions to seal. In this case, it's conditions to restore firearm rights. It's not a question of what is good, what is bad, what is the societal ill that the legislature is trying to address here. Those, if we start asking those questions, we go down a rabbit hole, because now the state's going to come to court in every single vested rights case, and the state's going to say, well, the legislature intended to do this, so it's public safety, and vested rights don't apply. I think that's a slippery slope and not something that the vested rights analysis requires or has ever previously been used for. So with that, I will yield the I'm out of time. Thank you.
We'll save the rest for rebuttal. Thank you, counsel. Counsel.
Good morning. May it please the court. Nathan Sugg, Deputy Prosecutor of Snohomish County, representing the state of Washington. House Bill 1562 restricted the right to restore firearms by those who had previously lost that right by a prohibiting offense. It did so by updating the statutory framework to comport with modern research about who continues to present an elevated risk of gun violence. This case is about more than where someone may bring a petition to restore their firearm rights.
Well, here we have an individual with an out-of-state conviction. Do you think the legislature intended to deprive people coming with out-of-state convictions from ever receiving or restoring the right to carry arms?
I do, Your Honor, and I think that there is, in fact, a path for Mr. Arends here. Under 941-040 sub 3, this court, or excuse me, the legislature provided an avenue. He could get a pardon, an annulment, a certificate of rehabilitation, or an other equivalent procedure that demonstrated rehabilitation from South Dakota, and he would no longer be prohibited in Washington state.
Dealing with your first answer to Justice Madsen's question, which was about the public safety rationale for this bill, how does restricting only people with out-of-state prior convictions from having their firearms restoration right restored, how does that have anything to do with any public safety rationale?
The legislature opted to prioritize victim safety with a victim-informed evidentiary procedure in this case. They specifically required that this be filed in the jurisdiction that is most likely to have records and imposed a duty on prosecutors to identify and notify victims of this process. That victim may then provide information to identify that this person presents an ongoing elevated risk of violence, that they have in fact not complied.
How does that have anything to do with somebody who can't go back to any venue in Washington state, or for many of these people to any foreign state venue to do that? A lot of these foreign states have automatic restoration of firearm rights, so there's nobody to give notice to and no judge to say your rights are back. How does that have
Certainly.
anything to do with public safety?
Well, I think the legislature here has to prioritize uniformity and consistency across these cases. They've set up a statutory framework by which to identify those who present an ongoing risk. This is not a Second Amendment question. This court has said that these are individuals who have lost their Second Amendment right to possess firearms. This is a restoration.
Temporarily.
Based on the statutory framework, this court acknowledged, I believe it was in Dennis in the dissent, that as of 1995, there were only two classes of individuals then who could restore their firearm rights. Those who had 3 or more DUIs in 10 years and those who had been involuntarily committed. No one else was permitted to restore their firearm rights prior to 1995. The federal United States Supreme Court has also recognized in Rahimi that prosecution for a felony results in a permanent bar on possession of firearm rights. So yes, it is temporarily, but that is because the statutory right that exists here, that is a matter of legislative grace and one the legislature can amend as it pleases. Here, they have opted to prioritize victim involvement in these types of proceedings. Victims are those who are most at risk of DV abusers gaining access to a firearm.
But separating out people who have out-of-state convictions as being unable to restore their convictions, how does that have anything to do with prioritizing victim safety?
A felony domestic violence abuser from another state, their victim will not have an opportunity or have the same opportunity to participate in this process. If it was to be brought in a jurisdiction that was near or likely near where that victim resided or where that case happened, that victim would have an opportunity to demonstrate.
But those other states don't have this same restoration of rights process. Many of them automatically restore rights. And the notion post-COVID and post-Zoom that an out-of-state victim would not have any ability to participate in a far distant courtroom just seems not consistent with where we're at now with the technology in our courtrooms.
Certainly, Your Honor, and the legislature should likely consider that. However, the legislative intent in this portion here was to include and prioritize victim participation, as they are the ones who are at risk of the perpetrators of their crime gaining access to firearms.
Also, if we find that TK, in fact, was a public safety measure, the amendment was to advance public safety, are we bound by TK here? I mean, are we just on all fours, we're going to have to follow TK, or do you have a different view?
I do have a different view, Your Honor. I first would suggest and agree with counsel that this court rejected the state's argument that it was a public safety prohibition. Instead, consistent with this court's later decision in SJC, determined that this was a rehabilitative statute, right? This was about allowing juveniles who committed a mistake to mitigate the lifetime consequences of that mistake. And the purpose of the statute and the Juvenile Justice Act was to allow those individuals another shot. Unlike that, this is not about court records, this is about guns. This is about guns that would be possessed by individuals the legislature has determined present an elevated risk of gun violence.
Sure, they're trying to promote public safety.
This is exactly why I say this is not a case about petition, where to petition, because if the vested rights position were to be accepted by this court and granted and extended from the juvenile sealing and rehabilitation category into the firearm restoration category, there are a whole host of changes in this law that would become, that there would be a class of vested petitioners for whom this law would not apply. The new law included several practical changes. For example, it indicated that those individuals who commit new prohibiting offenses immediately before or during the petition process would likely no longer be barred if they were vested petitioners. Crimes such as stalking, cyber stalking, unlawful discharge of a firearm.
Counsel, help me out here, just help me out. So under TK, we said that TK and the two other petitioners had a vested right, even though the amendment was trying to promote public safety. I mean, I read the opinion that the public safety was rejected. I mean, it was a 6-3 vote. Dissent tried to raise that, but the majority didn't do it. Here, all you're doing is the same thing. This amendment, which you're just talking about, the cyber stalking, the domestic violence, all is intended to promote public safety. Aren't we bound by TK?
No, TK actually provided two, I would say, areas for this court to look at when determining whether a vested right should apply. They're both based on legislative intent. It's the subject matter regulated by the statute as well as the statutory language. The statutory language argument here is that there is a prior offense that must be considered at the time of the petition, and that prior offense suggests the legislature's intent was to make the triggering event of the statute.
But wasn't that exact argument rejected in TK?
That argument, there was a similar argument in TK, but here we also have the argument that the subject matter being regulated is different. And I guess this goes to Your Honor's question, which is whether or not the public safety justification offered by this TK was actually accepted by the court. I would submit that the justifications, as the Court of Appeals concluded, the justifications between the Juvenile Justice Act, this court's determination in SJC, the frequent recitation that children are different, there is a recognition that the juvenile rehabilitation in our state's courts is a different purpose. The public safety argument presented by the state in TK was in fact rejected by the court. This court did not find public safety was the legislative intent that had been offered by that statute.
We're going to have to find public safety as the intent behind this statute because it says so explicitly in the legislative history, doesn't it?
I would agree, Your Honor. Yes, there's an extensive intent section to House Bill 1562, which makes clear that the legislature's intent was to regulate public safety and do so by restricting firearm access to those who had previously lost by a prohibiting offense.
They also address the Dennis decision, clarifying that they didn't mean any 5-year period. It had to be the 5-year period immediately preceding the filing.
It was remedial in that respect, yes, Your Honor. It made several other changes. In addition, it did ease access to firearms in specific circumstances. Those who had an issue with the 5-year crime-free period, under the former law, they were required to have no crimes in that 5-year period. Under the new statute, they're no longer, now those are just prohibiting offenses. So if there is a theft 3, for example, in that 5-year window, that's not going to have an impact under the new law. Defendants were also previously required to have completed all legal financial obligations on certain prohibiting offenses. That was removed. Now, if an individual has not paid their non-restitution legal financial obligations, they're still eligible for restoration. So the law identified what the modern research had said about who presents a risk of gun violence, and it restricted firearms from those individuals. It also looked at some of those parameters that had been in the former outdated law and removed some of the bars that were not directly tied to public safety on more equitable concerns.
Counsel, are we really concerned about the, I guess, well, let me put it this way. The portion of the statute that counsel is urging has become a vested right is a procedural aspect of the statute, that is venue. Do you see any difference between whether or not a venue provision might or might not vest versus the substantive aspects of a statute, in this case being crime-free for X amount of time?
I don't think the court can draw a line there. I think under the vested rights doctrine, if the court were to say that rights vested under the statute, the lower court would be obligated to issue a firearm restoration order. I don't think that there is any way that a line can be drawn to distinguish certain requirements of the former statute from those requirements of the newer statute. Instead, anybody who's deemed to be vested would satisfy whether or not the legislature determined they were an elevated risk of gun violence and whether or not substantive portions apply. They would have a right that had vested, and they would be entitled to proceed under the former statute. And that is a huge public safety concern and risk going forward. And furthermore, the legislature is unable to address this court's decision finding vested rights. Division 2 has explicitly acknowledged this. It's also in the court's decision in Carrier that even if the legislature came back and said, we did not intend for vested rights to exist here, this court would not give credence to that. Those vested rights had vested and can never be taken away. This court's decision would be the final decision for all of those petitioners who would come before. And I think the point of, the question offered by Justice Mungia about which version of the statute applies, if the court were to accept this, there would be a huge administrative burden going forward. In essence, lower courts would be asked to understand every amendment that happened from the beginning of the statutory history to the end. Mr. Arends' conviction was in 1988, and it's not exactly clear when his rights or under what version of the statute it may have vested. Frequently, these petitions are brought by individuals who are pro se. The court would need to understand every amended version of this statute and determine whether a petitioner satisfied any version of this statute at any time. The court would need to know that Dennis applied to the pre-2023 version and other decisions applied to other amended versions, but Dennis did not apply to the post-2023 versions. There's essentially would create a massive body of law for lower courts.
You're not going to argue that we're not going to find a vested right exists because it's just too complex to enforce, are you? I mean, I understand, and I agree with you. If this thing's a vested right, this was a court commissioner, this is a pro tem court commissioner who's given a form. I understand exactly what you're saying, but on the other hand, if it is a vested right, we don't draw a line because, it's going to be really hard to enforce that vested right. Or are you arguing that?
No, I would agree with Your Honor. The subject matter of the statute, the statutory language controls this question.
So is what you want us to adopt is if the legislature changes a statute, amends a statute where the purpose was to advance public safety, then you cannot have a vested right? Is that what you want us to hold?
I think that is one consideration that goes into the vested rights analysis. There are problems, as I've identified, with vested rights analysis, and this court has so far extended it only to the vacating and sealing areas of law because those areas deal with rehabilitation. This court has consistently denied requests to extend it outside of those two arenas, and this court should continue to deny extensions of vested rights doctrine outside of those two arenas. Here, there is no real, well, I'll pause on that.
Could I ask you to address what I was talking to opposing counsel about, and that is the venue for this? The statute changed the venue and limits it to the county where the offense occurred. But every court in the state of Washington, Superior Court, has jurisdiction over these cases, and venue, there has to be a motion to change venue if one party feels the venue is improper. That wasn't done here, or it was done here? You objected or moved to transfer venue?
Yeah, the order that was entered indicated that Snohomish County was not the proper court, and appears that was rejected by the commissioner on that basis.
But of course, it is a proper court in the sense of having jurisdiction.
At least under Manuel, yes, Your Honor. The court determined that at least the former statute's provisions were not jurisdictional. There was a question at the time, but they were not jurisdictional. They were venue requirements. I haven't done the analysis to figure out whether those arguments would continue to exist, but I'm sort of in agreement with Mr. Kertchen that this case before you is not really a venue case because this would, in fact, excuse those vested petitioners from compliance with all elements of the new statute. I wish we had received a decision from Division 3 on this question in Casale, but there is an open question here. I know that there's the legislature is concerning potential fixes to that same issue during this session. But I would agree that yes, assuming it is still only a venue requirement in the new law, there is jurisdiction within the Superior Court, and judges could act with that jurisdiction if there is no proper venue otherwise.
Could I ask as a follow-up? I'm not sure I hear your argument about why this case differs from TK, for example, as leaving that entirely open. Because you seem to be saying that this isn't just a venue jurisdiction question, this is the heart of the public safety rationale, because it intends that the local prosecutor will find the victims, and this is a victim-involved process, which feels very substantive. So maybe if you could address it in that vein, because one of the things that slows me down on TK, when I initially look at this case, I think, well, you have to not have any charges at the time the petition is granted under either version, and so when did it really vest? If that, we don't know whether that portion is met until the order might issue. But that argument was rejected in TK. There was a similar crime-free requirement for obtaining relief, and the court said that doesn't go to the vesting question, that might go to whether you ultimately get relief. So can I take you back then, if you seem to be saying this isn't really a venue provision here because it's essential to having the relevant public safety information in front of the decision-making body?
Yes, sir. I believe that we are squarely outside of TK because TK did acknowledge that it is both the statutory language, which would be prior offenses at the time of the motion or petition, as well as the subject matter being regulated. That is a question of, did the legislature intend the precipitating event in this arena, knowing this context of what is seeking to be regulated by the legislative action? In that context, do vested rights further that legislative intent? And here, what is being regulated is the safety of all Washingtonians. It is reducing firearm access by those who would present that risk. Vested petitioners, regardless of that finding, would be eligible. I think the most pressing changes for this case specifically would be that a court would no longer be able to consider whether a petitioner could pass a law enforcement background check. That is a requirement of the new law. Even a petitioner who law enforcement indicated may not pass a law enforcement background check would still be.
So can I ask you about that? If in fact under Manuel and looking at venue versus substantive provisions, would this be an issue-by-issue type analysis that may be vested so that the venue provision, the venue ability to obtain relief vests, but the substantive provisions are the current provisions?
Again, Your Honor, I don't see a mechanism by which the court could divide the substantive mechanisms or the substantive portions of the law from the procedural. I think whether it's law enforcement background checks, whether it's the closing of the loophole about compliance with felony sentencing conditions. Previously, the old statute only required misdemeanor prohibiting offenses to have completed sentencing conditions. If you were a felony offender who had, in fact, not completed domestic violence batterers treatment or not completed substance use disorder treatment, that was not a concern of the court. That was addressed. And that's actually what the commissioner in this case found, that Mr. Arends had not demonstrated that he had satisfied the conditions of sentence, or in the alternative, there were no records available, completed the attestation that he had sought those records and been unable to provide them. I don't see a way to divide those sorts of substantive changes from the procedural change here until the legislature acts further, and I know that it is looking at this question. If there are no further questions, I would ask this court to affirm the lower court, and thank you.
Thank you. Mr. Kertchen.
Thank you, Your Honor. The question of rehabilitation and the finding of rehabilitation and the TK decision. The TK court did not hinge the outcome and the holding in that case on a finding of rehabilitation or the fact that the juvenile statutes the sealing statutes exist for rehabilitative purposes. That finding that the state and the Court of Appeals cite didn't come until 2015, which is the SJC case. The outcome in TK was based on the statutory language of the statutory language, the subject matter, the precipitating event, which is the correct framework for a vested rights analysis. If we consider TK, what happened was the legislature tried to make sealing harder or to take away sealing completely from certain individuals that the legislature thought was deemed more dangerous. That's more or less exactly what Mr. Sugg is arguing today and what this court rejected in TK. The subject matter in this case is not different than the subject matter in TK because we have to remember what subject matter means. The relief granted by the former statute, the firearm restoration statute, is different than the former juvenile sealing statute. But the subject matter is still the prerequisites for relief. That was the case in TK. That's the same case here. If public safety becomes the linchpin in these vested rights cases, where the courts start looking at public safety to determine the vested right, then the floodgates open. In the context of criminal matters, for example, in Ray Carrier, or in firearm restoration matters, we can basically kiss vested rights goodbye. There's no longer anything tying the law to a vested right. The state will come to court every single time, and the state will say the legislature is doing this for public safety purposes, therefore there's no vested right. So what the state's asking the court to do is deviate significantly from the way vested rights have been analyzed for decades.
Can I ask if you agree with Mr. Sugg that if the prior statutory process, if that vested right applies, you take it all, in for a penny, in for a pound, whatever the criteria were, even if the subsequent legislation has limited the disqualifying offenses, et cetera, made it more possible for more people to have restoration, but eliminated the venue, you get the whole former statute and you don't get the advantage of anything new?
Well, we get the advantage. That's correct, Your Honor, yes.
Okay.
Yes.
Well, counsel, is your client vested under the 1995 statute?
I couldn't answer that, Your Honor. I don't know.
If he met all the requirements under the 1995 statute, wouldn't he be vested under your analysis?
I believe so. I honestly, Your Honor, I don't remember when he moved to Washington.
No, I'm saying if he met all the requirements.
I believe so, Your Honor. One of the things that
That's one of the things that whoever's going to petition now is going to have to go before a court commissioner and try to figure out which statute applies, because in fact, let's just add in one more thing. So the 2011 statute had been amended, let's say in 2014, and your client, let's just say, that needed 2 more years of the 5-year term. We wouldn't apply the 2011 statute, we apply the 2014 amended statute, and he'd have to meet all those requirements, right? Because he wouldn't be vested yet.
Yeah, I think the answer to your question, if I understand it, is yes. What I would say is this notion that this is too difficult for trained lawyers and judges to figure out that holds no water in my book whatsoever. We're all trained on how to do legislative research. Commissioners and judges are all lawyers, and we have learned judges, and I don't think that the fact that something may be slightly more complicated in terms of legislative research or looking back in history as to what statute applied, that's never been a barrier to vested rights, nor should it be a barrier to vested rights.
Counsel, is there any difference between TK and your case in the sense that you're giving new rights or restoring rights that are outside of the court system, in a sense, in your case, but in TK, it was a matter of sealing court records?
Chief Justice Stevens, I'm out of time. May I answer the question?
Yes, you may.
Thank you. Okay, sorry. I'm not sure I totally follow your question, Your Honor.
Well, you're giving new rights to a person that have been taken from them. So you're giving new rights to a person who doesn't otherwise have them. In TK, there's no rights involved. It's a matter of sealing records, which could be unsealed if the person becomes, reoffends, because
Sure.
that was a provision. You could get those records unsealed.
Sure.
So is there any difference in terms of what you're getting in terms of the statute here versus what was available as relief in TK?
No, I don't see, again, the relief granted is certainly different. I don't see that that's a distinction that's material to the outcome of this case or to the applicability of TK to these facts.
Thank you. We want to thank both counsel for your arguments. The cases this morning are submitted and the court's adjourned.